that have languished for years have moved forward, and the backlog of enforcement actions has been significantly reduced. I think you all deserve credit for that. Additionally, each year the Commission shares with those in this committee and within the Congress bipartisan legislative recommendations, and many of those high priority reforms are common sense and merit serious consideration. I'm grateful for that as well. At the markup of the ACE Act, committee Democrats offered several of the proposals that you've asked for in terms of common sense changes. Unfortunately, they were rejected. I'm hopeful today's hearing will help my colleagues see a path forward on some of these bipartisan requests, so I appreciate that. In particular, the committee's successful administrative fines program sunsets at the end of this year and I believe should be extended. I hope you will agree with me. I would ask the chairman and colleagues on both sides of the aisle to support that, and I think we should do that as quickly as is possible. And I want to commend the thorough and diligent work of your staff. I think they are dedicated public servants helping to ensure our elections are transparent and accountable, and they have worked tirelessly to provide exhaustive answers to the dozens of questions that we on this side of the committee have asked over the past year, so I'm grateful for that and your leadership in that regard. The FEC's written testimony highlights many of these same examples of progress, and progress for its own sake, however, is not the sole benchmark of success, and I just want to spend a moment or two just talking about this. The committee needs to assess whether the sole mission of the FEC is being fulfilled, and that is protecting the integrity of federal campaign finance process and ensure transparency for the American people. On this score, the FEC's own statistics are revealing, and I'll get into this a little now and then in our question. The numbers tell a story of disagreement and deadlock, especially on the most important issues facing the FEC. So under current law, the FEC's nonpartisan career staff cannot investigate enforcement matters without the affirmative vote of 4 or more commissioners. When commissioners deadlock with a 3-3 vote on an enforcement case, 3 commissioners are able to effectively block an investigation in its entirety, preventing any possibility that the FEC will ever hold the alleged wrongdoers accountable. So think about this. Professional staff makes a recommendation. Without the assent of 4 members of the panel, the investigation can't continue. Since the 2010 Citizens United decision by the Supreme Court, which opened the door to super PACs, dark money, and unlimited contributions for elections, raising the stakes even higher for your enforcement agency, the FEC has failed to act in dozens of cases where the nonpartisan professional career staff recommended otherwise. And I just want to cite some statistics in the remaining moments I have. The nonpartisan career staff recommended action in 59 matters alleging unlawful coordination between committees. The commissioners did so in just 7 of those cases, not judging whether they were with or without merit in the final, but just whether or not an investigation should continue. In matters requiring dark money groups to register and report with the FEC, the Commission acted on only 5 of the nonpartisan career staff's 24 recommendations. On foreign interference, the FEC has acted on barely half of the nonpartisan career staff's recommendations. Most troubling, in my mind, is the FEC's apparent partisan enforcement of matters related to former President Trump. To date, the FEC has considered 56 matters involving allegations that the Trump organization violated the law. After reviewing these matters, the nonpartisan career staff recommended commissioners find reason to believe a violation occurred in 26 of those 56 matters. Republican commissioners voted down all 26. These votes carry the unmistakable odor of partisanship. And considering the data provided this committee on the most crucial matters facing the FEC since the Citizens United decision, 12 out of 109 nonpartisan staff recommendations have been advanced, meaning you have about a 110 batting average with the commission. As a devout fan of the St. Louis Cardinals, sorry, Milwaukee Brewers, you wouldn't be playing not only for the Cardinals, you wouldn't be playing in the minor leagues or anywhere else in baseball if you had 110 batting average. So it raises the question, and I know I'm running out of time, so I'll just summarize and I'll come back to it with questions, but we need to seriously think about whether the nonpartisan professional staff is going to be allowed to investigate matters they think are appropriate. And then you can adjudicate as you see fit, but at least allow them to investigate. So with that, Mr. Chair, I'll yield back.
I would note to the ranking member, 110 batting average may allow you to play for the Yankees this season. Where's Mr. De-Esposito when you need him? Without objection, all other members' opening statements will be made part of the hearing record if they're submitted to the committee clerk by 5 p.m. today. Today we have 2 witness panels, beginning with the commissioners of the Federal Election Commission. After all members have had the opportunity to question our first panel, we'll then move to a second panel with FEC Inspector General Christopher Skinner. Pursuant to paragraph B of Committee Rule 6, the first panel witnesses will please stand and raise your right hand. You solemnly swear or affirm that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show the witness answered in the affirmative and may be seated. I'll now introduce our witnesses. Our first witness is Chair Darrell Lindenbaugh, nominated as a Democrat in May of 2022. Prior to her appointment, the chair worked as an attorney where she advised candidates, political committees, and organizations on campaign finance and election law. Our next witness is Vice Chair Sean Cooksey, was nominated as a Republican in December of 2020. Prior to his appointment, Mr. Cooksey served as general counsel to U.S. Senator Josh Hawley, working on the Senate Judiciary Committee and advising the senator on issues including constitutional law, judicial nominations, election law, and an array of other issues. Next, we have Commissioner Shauna Bossard, who joined the commission in 2008 as an attorney in the Enforcement Division of the Office of General Counsel. The commissioner was nominated as a Democrat in December of 2020. Next, we have Commissioner Alan Dickerson, who was nominated as a Republican in December of 2020. Prior to his appointment, he was legal director of the Institute of Free Speech, where he led a nationwide First Amendment litigation practice. We also welcome Commissioner Ellen Weintraub, who served as commissioner of the U.S. Federal Elections Commission since 2002 and chaired it for the 3rd time in 2019. The commissioner was appointed by George W. Bush as a Democrat on the commission via recess appointment in 2002 and was confirmed by the United States Senate in 2003. And finally, we welcome Commissioner Trey Traynor, who was nominated as a Republican in May of 2020. The commissioner has practiced law for 2 decades in the areas of election law, campaign finance law, and ethics. We appreciate you all being with us here today and look forward to your testimony. Please remember the microphone's in front of you and you have to pull a little bit close to you. And I know we got all 6 of you at a big table. You'll have 5 minutes for your testimony. We'll begin with you, Chair Lindenbaum.
Thank you. Chairman Steele, Ranking Member Morelli, and members of the Commission, thank you for inviting me to speak about the Federal Election Commission. As the newest member of the FEC and this year's chair, I'm delighted to share our agency's critical work, achievements, challenges, and the path forward. The core mission of the FEC is to ensure transparency, compliance, and fair enforcement of the federal campaign finance laws. No more than 3 of the FEC's 6 commissioners may be affiliated with the same political party. Because 4 votes are necessary to approve most agency actions, we must cross party lines to find common ground on issues ranging from staffing levels, to budget priorities, to regulatory language, to enforcement matters. Of course, we'll have meaningful disagreements, but I've made the focus of my chair year ensuring the FEC is a modern, functioning agency. I'd like to share some of the many improvements and changes we've made this year and highlight some of our lesser-known but mission-critical programs. I'm proud that after years of internal hand-wringing and external frustrations, we successfully revamped our audit procedures, resulting in a process that strikes the appropriate balance between efficiency, procedural protections for audited committees, transparency, and encouraging voluntary compliance with the law. In April of this year, we approved and updated our Memorandum of Understanding with the Department of Justice, which establishes the guidelines for the FEC and DOJ to share information and advance the mission of both agencies. We have 2 new open public comment periods. The first is a notice of availability of a petition for rulemaking surrounding the fraudulent misrepresentation of campaign authority through artificial intelligence in campaign ads. The second is a comment period to identify the ways to improve our filing systems and the usability of our website ahead of the 2024 elections. This also includes downloading information from our website and how you view it. Improving our hiring and personnel processes has been one of my highest priorities. On the Personnel Committee, Commissioner Traynor and I timely approve hiring vacancies and use our experience from the private sector to speed up staff hiring and find new recruitment streams so that we don't miss out on talented candidates. The FEC's educational opportunities aimed at promoting voluntary compliance with campaign finance laws continue to be a success. Our information division has excelled in creating engaging, cost-effective educational programs from the regulated community, consistently receiving high praise for their exceptional presentations. Our dedicated information division and reports analysis division play pivotal roles, answering thousands of calls each year with substantive questions about campaign finance rules and regulations and intricate reporting questions. These callers often have limited resources to hire lawyers and other experts, so our patient and dedicated staff ensure that those engaging in the political process have access to the information and guidance they need to navigate the complexities of campaign finance law and maintain compliance. Of course, significant challenges remain that require additional funding. Historically, the FEC has not asked for or received sufficient funding to keep pace with inflation or the rapidly increasing volume of transactions reported. This has put us in a dire situation with increasingly outdated and vulnerable IT systems as the volume of transactions continues to increase. In 2022, we advocated for a meaningful increase in funding for fiscal year 2023 to allow our agency to begin meeting these challenges. Our recent successes with hiring and beginning the long overdue upgrades to our IT infrastructure are due in large part to our increased appropriation from Congress in fiscal year 2023. With continued investment in future appropriations, we can continue to build our workforce and fortify our IT systems in the face of ever-increasing spending. I've had the privilege of sitting in on staff meetings across the agency over the past few months to acknowledge and thank our staff for their work, and I have been consistently impressed by their professionalism and dedication. Despite working with antiquated systems and limited resources, our staff continue to bring energy and creativity every day to further our mission of ensuring transparency, compliance, and fair enforcement of the federal campaign finance laws. I look forward to taking your questions.
Thank you very much. I now recognize Vice Chair Cooksey.
Good morning, Chairman Stile, Ranking Member Morelli, and members of the Committee on House Administration. It's an honor to appear before you today to testify about the work of the Federal Election Commission and to answer your questions. My name is Sean Cooksey, and I currently serve as the Commission's Vice Chairman. I've submitted lengthier written testimony to the committee, but in the limited time I have, I would like to raise 2 points. First, as Chair Lindenbaum discussed, since the Commission regained its full slate of commissioners at the end of 2020, the agency has been hard at work again. Let me give you a couple of examples. In the last 33 months, we have cut our enforcement backlog by more than half, from 446 enforcement matters pending when I arrived to 198. That includes a 92% reduction in the number of reports waiting for commissioners' action, from 223 reports sitting on our desks to now just 19. Importantly, of the more than 500 enforcement matters that the agency has completed since January 2021, the Commission reached some kind of bipartisan agreement in 90% of them. Oftentimes, those cases were decided unanimously. Similar statistics are true for other areas of our work, such as advisory opinions and regulations. This is not to say that the job at the Commission is easy or that we do not frequently disagree. We do. But I assure you, my colleagues and I are doing our level best to work together, to apply the law to the facts before us, and to craft policies that fulfill our agency's mission to the American people. The second point I want to raise is a request. As Ranking Member Morelli mentioned, the commissioners before you are making every effort to improve the agency, but some things only Congress can do. The Commission's top legislative recommendation to Congress is to extend or make permanent the Commission's administrative fine program, which is set to expire at the end of this year. The administrative fine program authorizes the Commission to assess standardized fines for basic campaign finance reporting violations and to thereby avoid putting campaigns through the slower, more expensive enforcement process at the Commission. The program works well. Last year, in 2022, the Commission issued over $1 million in administrative fines. It saves the government and taxpayers money, and it promotes fast and fair enforcement of the law. That's why Congress has reauthorized the program 6 times before, but we need Congress to do it again. Last week, the House of Representatives was sent legislation that reauthorizes the program for another 10 years after it passed unanimously in the United States Senate 2 weeks ago. I would urge the House to pass S2747 and to send it to the President's desk. It is the most direct and immediate way that this committee can help improve the FEC. I would like to end with a note of thanks. First, I would like to thank the career staff at the FEC. Without them, the work of the agency would not be possible, and the agency's accomplishments belong more to them than to any commissioner. Second, I would like to thank the members of this committee and their staffs. Congress's oversight of the executive branch, and especially of independent agencies like the FEC, is critical to ensuring the democratic accountability of our government. I know firsthand that this would not be possible without the tireless efforts of dedicated staffers in each of your offices. With that, thank you again for the opportunity to testify, and I look forward to taking your questions.
Thank you very much, Commissioner, Vice Chair Commissioner. And I'd now like to recognize Commissioner Broussard. We'll hardly see the light, but it often works.
Is it? Thank you. Appreciate it. Good morning. Good morning, Chairman Stiles, Ranking Member Morelli, and members of the committee. Thank you for inviting me and my colleagues to testify today. I'm eager to highlight the agency's accomplishments before our Oversight Committee. We have had a full complement on the Commission since the Senate confirmed me and 2 of my colleagues in December of 2020. And while there have been notable challenges since then, I remain committed to transparency, fairly enforcing our campaign finance laws, and fostering an agency culture that builds on the dedicated efforts of my former colleagues at the staff level. I consider service on the Commission a privilege. Indeed, my commitment to the agency and its mission began long before my appointment, beginning in 2008 as a staff attorney in the Commission's Enforcement Division and later as counsel to a commissioner. Those experiences allowed me to develop not only legal knowledge, but an understanding of the agency that gives me a unique perspective represented on the Commission. Today, I can look back on almost 3 years on the Commission with a measure of satisfaction and some concern, and I look forward to future years with continued dedication and hope. I take satisfaction in having led the Commission's dramatic reduction of the enforcement docket backlog, following a loss of a quorum of 15 months and under the uncertainty of a global pandemic and an executive order for government-wide remote work. When the quorum was restored, the backlog stood at 450 matters and slightly exceeded that number when I assumed the chair in January 2021. This was almost 75% from when the Commission lost the quorum. But by October of 2021, through a disciplined and methodical approach, the Commission had closed 194 matters, which was the highest number achieved since fiscal year 2009. While I'm proud of this achievement, I'm not oblivious to the potential for a backslide with the likely increase in the number of agency actions as we enter a presidential election. But at the same time, the Commission has experienced significant attrition. Agency staff levels thinned to 260 at fiscal year 2022. This means that fewer staff shoulder the rising workload, which risks a negative effect both on employee morale and on the agency's capacity to timely respond to enforcement matters and advisory opinion requests. But thanks to the effort of Chair Lindenbaum and Commissioner Traynor, as of today, our agency FTEs stand at 305 with more to come. Above all, I am hopeful. On the Regulations Committee, I advanced a long-standing rulemaking with the joint effort of my co-chair, Commissioner Alan Dickerson, whose keen analysis only sharpened our focus and won wider support for our efforts. Significantly, since 2011, the Commission had been considering an internet disclaimer rulemaking. Last December, the Commission published a final rule. Beginning last year, I have led an effort that is a passion of mine. The issue, the ability for candidates to use campaign funds for compensation while they are campaigning, has both a macro and micro implications. On a micro level, it's about opening the possibility of running for federal office for a diverse population. On a macro level, it enables our democracy to become more perfect by creating opportunities for our federal elected bodies to reflect the demographics of our nation. In December of 2022, the Commission formally initiated a rulemaking, and we are now in the process of negotiating final rules. Finally, after a 3-year lapse, in 2021, the Commission submitted bipartisan legislative recommendations that can help strengthen the agency and the laws we enforce. I was excited to see the Senate pass a bill to extend the admin fines program for 10 years. But I also want to urge this committee that bipartisan support in strengthening FECA, the prohibition against all foreign national involvements in our campaign process, is needed. In closing, I am inspired now as ever to serve the commission. Your continued support can help fulfill our mission, and doing so, cultivate public trust in our electoral process and elected officials. I thank you again for the opportunity to appear today.
Thank you, Commissioner Broussard. Commissioner Dickerson, you're now recognized.
Good morning. Thank you, Chairman Stile, Ranking Member Morelli, members of the committee. I also want to begin by thanking you for holding today's hearing. The Federal Election Commission's been given an especially delicate mission, regulating activity at the core of the First Amendment's protections for political speech and association. Precisely because that work is difficult, we do it best in dialogue with Congress and the courts. After more than a decade without a formal oversight hearing, I am honored and gratified to join my colleagues here today. This is a new commission. On a body designed for staggered 6-year terms, 5 of us have served for less than 4. We inherited an agency that had lacked a quorum for virtually the entirety of the 2020 election cycle, and where a backlog of enforcement cases and regulatory matters had grown to an unprecedented level. Today, joining the chorus, the situation is very different. Taking the gavel on virtually her first day as a commissioner, Shauna Broussard drove hard to resolve hundreds of stale enforcement matters and to clear the decks for future work. And that vital effort has allowed the commission to focus on long-needed reforms. More than a decade after the D.C. Circuit's decision in Speech Now versus FEC, we amended our PAC organizational forms to recognize the existence of super PACs. We successfully concluded a rulemaking on internet disclaimers that had laid dormant since 2011. We completed a top-to-bottom review of our auditing procedures. Each of these decisions was made on a resoundingly bipartisan basis. These successes illustrate, I think, the leadership of my colleagues and our willingness to work with each other to find common ground against a challenging legal backdrop. It's common to begin discussions of the FEC by invoking Judge David Tatel's pointed observation in AFL-CIO against FEC, that the commission is unique in that it has as its sole purpose the regulation of core constitutionally protected activity. And that's certainly true. But the late Justice Antonin Scalia put his finger on perhaps a deeper problem. He observed that campaign finance law is so intricate that he couldn't figure it out. That complexity is the result of Congress's consistent failure over decades to update the law to respect judicial precedent, with the commission and ordinary Americans caught in the middle. And it's not new. Back in 1976 in Buckley versus Vallejo, 7 members of the Supreme Court, including Chief Justice Burger, but also including Justices Thurgood Marshall and William Brennan, held that the phrase, quote, "for the purpose of influencing an election," end quote, the keystone term in the act, was unconstitutionally vague. Such a distinction, they noted, offers no security for free discussion. In these conditions, it blankets with uncertainty whatever may be said. It compels the speaker to hedge and trim. As a result, we're unique in another way. We're the only federal agency whose governing statute has been in judicial receivership since its inception. So much of the act has been held unconstitutional over so long a period of time that with every passing year, it becomes more difficult for ordinary Americans and even most specialists to understand what is and is not permitted. There are many downsides to this state of affairs, but I want to highlight just one more. Because the text of the act and the reality of the law are so qualitatively different, it is easy to fall into false certainty about what the law actually is, and all too easy to perceive illegality rather than thorny questions, especially where one's political opponents are involved. Because the Commission's enforcement efforts are driven in large part by third-party complaints, there's a clear incentive to use the complaint process and to suggest, from ignorance or malice, that a novel question is in fact clear or obvious, and to blame the Commission when it takes seriously its duty, as the Supreme Court put it, to ensure that the tie goes to the speaker and not the censor. Fortunately, while my colleagues and I sometimes disagree on the correct interpretation of the law in particular cases, I do believe we share a commitment to simplifying and explaining the law so that average Americans who wish to participate in our political process may do so without peril. As Justice Kennedy, writing for the court in 2010, properly stated, the First Amendment does not permit laws that force speakers to retain a campaign finance attorney before discussing the most salient political issues of the day. Thank you again for the invitation. I look forward to your questions.
Thank you, Commissioner Dickerson. Commissioner Weintraub, you're now recognized.
Chairman Steele, Ranking Member Morelli, and members of the committee, thank you for inviting me to testify today. I'm pleased to be here with my colleagues on behalf of the Federal Election Commission to discuss the important work of our agency. I can't say this is the most exciting thing that I'm doing this fall because my daughter's getting married in a couple of weeks, but this is a close second. The FEC is charged with administering and enforcing the federal campaign finance laws and providing public disclosure and transparency in our elections to empower a well-informed electorate, a goal the Supreme Court has robustly endorsed since the seminal 1976 case of Buckley v. Vallejo. I sit at this table with my fellow commissioners, but the agency is not made up of only 6 individuals. While we take the votes, we cannot fulfill this agency's crucial mission without the hundreds of people who are not at this table. Our FEC staff is made up of some of the most dedicated public servants I have ever met. They are diligent, thoughtful, and provide great service to the American people. I would be remiss if I did not take this opportunity to thank them for all of their hard work and commitment to the mission of our agency. The FEC has been through a lot in the last few years. We went through a total of 15 months during the record-shattering fundraising of the 2020 election when we did not even have a quorum of commissioners to make decisions. That ended at the end of 2020 when we regained a full complement of commissioners for the first time since 2017. We have been pretty busy ever since. Not surprisingly, we had quite a backlog of enforcement decisions to make when we regained the quorum. But we were fortunate in 2021 to have the steady and determined leadership of then-Chair Broussard, who made attacking the backlog a top priority. Thanks to her efforts and the continued focus by 2022 Chair Dickerson and 2023 Chair Lindenbaum, and the hard work of all of my colleagues, we have virtually eliminated the backlog of cases awaiting decisions by the Commission for the first time in many years. Now, I didn't agree with the outcomes of each of those decisions, but eliminating the backlog so that cases do not languish and fall due to the statute of limitations is an important accomplishment. Public confidence in the political process depends not only on laws and regulations to ensure transparency, but also on the awareness that those who disregard the campaign finance laws will face consequences. In that regard, I want to highlight the updated Memorandum of Understanding with the Department of Justice that the Commission adopted in April of this year. I want to thank Vice Chairman Cooksey for partnering with me on an ad hoc committee to oversee this project, and I particularly want to thank the leadership of the Department of Justice, who made this a priority and worked cooperatively with us to get it done. I believe this agreement will aid in effective enforcement of the law, a goal that the American people expect and deserve. So there have been accomplishments, and I want to thank Commissioner Traynor, who serves with me on the press committee, for helping to ensure that the public is informed about those accomplishments. But as always, there is still plenty of work to be done. We have made strides on the rulemaking front, thanks to the efforts of Commissioner Broussard and Commissioner Dickerson on our Regulations Committee. Important rulemaking projects are ongoing, such as our efforts to update our rules on candidate compensation to make it possible for citizens from all walks of life to consider public service. Here, too, however, we face a backlog of projects. It has been more than 13 years since the Supreme Court's Citizens United decision and its progeny created the entities we now know as super PACs, but we have yet to promulgate regulations governing them. Our coordination regulations have not been updated to take into account the significant role that super PACs now play in the campaign finance arena, and the old rules are not adequate to bear the weight that has been placed upon them. Citizens United reiterated the importance of disclosure, the heart of the FEC's mission. The court explained that disclosure enables the electorate to make informed decisions and to give proper weight to different speakers and messages. Or as Justice Scalia put it in his concurrence in Doe v. Reed, requiring people to stand up in public for their political acts fosters civic courage, without which democracy is doomed. Undisclosed dark money is a large and growing problem that undermines the court's promise of transparency and the FEC's fundamental mission. The FEC can and should do more to address it, and we have just begun to deal with new challenges such as the potential role of artificial intelligence in campaigning. I want to echo my colleagues' advocacy for our unanimous legislative recommendations, including extending the successful administrative fine program and amending the FECA to expand protections against foreign influence. And I'd like to put in a plug for our budget request, which would allow the agency to continue to meet its increased workload and make needed updates to the agency's critical IT infrastructure. Progress has been made, but challenges remain. dark money, foreign malign influence, new technology, cybersecurity, AI, budget constraints. These are just a few of the issues confronting the FEC. I stand ready to work with my colleagues at the FEC and with our oversight committees in Congress to address these challenges. I look forward to a productive exchange here today toward that goal.
Thank you, Commissioner Weintraub, and congratulations to your daughter on her wedding. Commissioner Trainer, you're now recognized.
Thank you, Mr. Chairman. Thank you, Chairman Steele, Ranking Member Morelli, and members of the committee. It's an honor to appear before you today and to answer your questions. As I noted in my written submission, and as you've heard here, there's great bipartisan work being done at the FEC. Today, however, I'm compelled to draw the attention of this committee to a disturbing situation that has become increasingly prevalent in today's politics. To those who've been paying attention, the problem is stark. It's the growing weaponization of government to harass and hinder the political participation of our citizenry in the democratic process. The Federal Election Commission has become a weapon in two specific ways in that process. First, the Commission adopted new procedures that I believe are inconsistent with our statute and may violate the Constitution and are the gateway to criminalizing ordinary campaign activity. Second, the Commission entertains vague complaints regarding alleged violations of the Federal Election Campaign Act to the detriment of the rights of innocent respondents. Make no mistake, the current headlines about the criminal prosecution of political actors reflects a trend that is going to continue for the foreseeable future. Unfortunately, the Commission has become part of that problem. Earlier this year, the Commission and the Department of Justice entered into a new memorandum of understanding regarding how information will be secretly shared between two agencies. The Commission was established as an independent executive agency. As such, the Commission operates outside the normal procedures of the executive branch and specifically in a bipartisan manner. However, the new MOU brings the Commission squarely into the fold of executive agencies that routinely share information amongst themselves. Most disturbingly, members of the public are not given notice that their interactions with the FEC are memorialized by bureaucrats and could form the basis of criminal investigations. This is not just a hypothetical situation. Requests by the Department of Justice for us to stand aside so they can pursue a target are on the rise. Since I joined the Commission, there have been abatement requests related to 33 different matters, and most include document production requests. Critically in these cases, the Commission has acquiesced to the request to not alert those being investigated. The information has been requested by the Department of Justice. I believe this new MOU retards the First, Fifth, and Sixth Amendment rights of citizens who are actively engaged in the political process. I strongly believe that this information sharing should be halted and the independence of the FEC should be reaffirmed. Secondly, the Commission is seeing a significant number of complaints against so-called unknown respondents that a complainant alleged that someone or entity, the identity of which is unknown, has done something illegal. The Commission has received over 30 of these complaints since 2020, and they're problematic for two reasons. First, an unknown respondent complaint outsources a complainant's obligation to file an informative complaint. Compounding this problem is that such complaints are typically filed by ideological organizations that see an opportunity to have the legwork done at the taxpayers tab without regard to whether those allegations are true. Take, for example, the case of Mr. Derek Utley. Mr. Utley was an unknown respondent in a matter that ultimately took 4.5 years to dispose of. What was Mr. Utley's heinous act? He engaged in constitutionally protected free speech by anonymously publishing a Facebook page entitled Elect Trump 2020. So how did it happen? Well, a poorly sourced news article alleged that an unknown person, later identified as Mr. Utley, spent over $34,000 on shady Facebook ads. In 2017, a complaint was filed by Common Cause. In 2019, based solely on the news article, the Commission found reason to believe that a violation had occurred and launched an investigation. The result of the investigation? Mr. Utley had actually spent $483 on Facebook ads which should be protected activity under settled precedent by the U.S. Supreme Court. Mr. Utley's case is the textbook example of how the process has become the punishment. The ultimate outcome of Mr. Utley's multi-year harassment by the FEC was that his case was closed. Not closed with an exoneration, not closed with an apology for the bureaucratic inquiries that he had to withstand or the amount of money that he expended. It was just unceremoniously closed. All the while, the media outlet that misreported the facts and the group that filed a complaint without doing its own research walked away, having made Mr. Utley an example of anyone who dares share his political views. In conclusion, I'm proud of the bipartisan accomplishments we have at the FEC. However, at the same time, I am fearful of the continued weaponization of government against political participation. If this weaponization continues, I fear that American citizens will ultimately choose to forego participating in our political processes. That would be unfortunate, as their participation is the foundation of our republic. Sitting here as an FEC commissioner, I urge Congress to halt the secret sharing of information between the FEC and the Department of Justice, and to clarify that only complaints based on actual evidence are investigated by the commission. Thank you, and I look forward to your questions.
Thank you, Commissioner Traynor, and thank you to all for your opening statements. We're going to begin questions with Representative Lee and then alternate between the parties. Ms. Lee, you're now recognized.
Thank you, Mr. Chairman, and thank you to all of our witnesses for being here today. We appreciate your testimony and your attendance. I'd like to start, Commissioner Cooksey, with you and a little bit of background on circumstances in which individuals have a right to sue the agency for inaction. In particular, I'm interested in the circumstance where the agency is sued in court, but commissioners decline to defend the lawsuit. Is that something that you've seen occurring?
Thank you for the question, Representative. Yes, it is. So under our statute, as it's written, when a private party files a complaint with the commission, they have the right to sue the commission for undue delay if the commission doesn't act on their complaint in a timely manner, if we don't have a good reason for that. And if they win that lawsuit, they then gain a private right of action to sue the party they complained against directly for violating campaign finance law. To defend the agency in an undue delay suit requires a commission vote. It requires 4 commissioners to defend the agency, and it's something that was routinely done up until about 5 or 6 years ago, where there was a period of time in which a number of commissioners were engaging in a strategy of not only refusing to close case files that the commission had voted on. In other words, the commission had considered the merits of a case, had voted on it, had decided not to go forward, but then certain commissioners would refuse to end that case, to disclose it to the parties. And then when we were sued for undue delay, those same commissioners would block the agency from defending itself in court, so the government was basically a no-show in federal court.
And what happens when an agency fails to appear and is essentially a no-show after being sued in federal court?
Well, a number of things can happen. There can be show cause orders, there can be sanctions, but most typically what's happened is that the court simply issues a default judgment against the agency, and the party that sued us goes on and sues with their private right of action they've gained. And
how does the entry of a default judgment affect the FEC, and what happens next?
Well, it affects us in a number of ways. One, certainly we're, at the most basic level, we're not allowed to share what the commission has done, to share how we have acted on a case and to defend ourselves. And ultimately it leads to a sort of paralysis at the commission and our ability to get our work done.
And now, as you might be aware, the American Confidence in Elections Act, which is a piece of legislation that passed out of our committee just a few months ago, we require a unanimous vote of the commissioners in order to decline to defend the agency in court. Do you believe this would be a positive change?
Absolutely. I would strongly encourage Congress to change the statute that governs how the agency defends itself. I think it's, frankly, a scandal for the federal government to not show up in federal court to defend itself.
All right, thank you. I'd also like to touch on the something that you mentioned in your opening statement that I think it is important to highlight, and that is, I believe you mentioned that the large majority of your cases are resolved in a bipartisan way. Could you tell us a little bit more about that?
Sure. So, I think like many issues, people tend to focus on the division and to exaggerate it. But if you look at the overall enforcement docket at the commission, if you look at the hundreds of cases we've closed over the last 3 years, the vast majority of those we reach some kind of bipartisan agreement. It may not be unanimous. It may not be the exact same recommendations that the career staff have made. But 9 times out of 10. If you consider our entire enforcement docket, there are 4 commissioners, meaning at least 1 Republican and at least 1 Democrat, that can agree on some outcome to an enforcement matter.
And then I'd like to turn now to one thing that you also highlighted and that we commend you for is your significant work to reduce the number of cases, the backlog of cases that are pending. Nonetheless, you all are faced with a very large volume of cases and a very large workload. Would you speak with us a little bit about how discretion about which cases to pursue and which cases to close, how that affects your work and how that is important to your management of the overall caseload that you have?
Absolutely. So prosecutorial discretion is an important part of our agency and how we manage our enforcement docket. We, simply put, don't have the resources to pursue every single complaint for a number of reasons, and there are situations in which, in our judgment, it's throwing good money after bad, and to put it one way, to pursue certain kinds of enforcement cases that we don't think are worth our while relative to other priorities. And so the exercise of prosecutorial discretion is an important feature of how we manage our enforcement docket in order to essentially maximize the effect we have in enforcing the law.
All right, thank you. Out of time, Mr. Chairman, I yield back.
Thank you very much. Ranking Member, Mr. Morelli, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you again. I apologize. I did get a chance, however, to look at the written testimony from the commission, which observes the agency mission is to protect the integrity of the federal campaign finance process by providing transparency and fairly enforcing and administrating federal campaign finance laws. That's from your testimony. To me, that suggests that the agency strives to treat like cases alike and enforce the law when enforcement is merited. I was struck by the focus on fairly enforcing the law in light of the enforcement information the FEC has provided this committee on matters related to the former president, his committees, or close associates. It appears these cases, the approach has been overly partisan. And I refer to the comments I made in my opening just a few moments ago. But to Commissioners Broussard and Weintraub, you issued a statement of reason in matter under review 7784, Make America Great Again, PAC et al., that touched upon these concerns. In that statement, you observed that former President of the United States, Donald Trump, has been on a remarkable win streak before the Commission. After receiving dozens of complaints for violations in our laws, there have been 0 investigations. And I mentioned this earlier, that of the 56 matters that have been brought, 26 of them have had the professional staff urge the commission to proceed with at least an investigation, not a decision on whether to acknowledge either guilt or innocence or on the adjudication, but just on the question of whether to move forward. 26 out of 26 have been blocked. How would this, in your estimation, suggest that the commission is fulfilling its mission to fairly enforce the law? And I ask the 2 authors of that memo if they'd like to comment.
Thank you for the question. I think our statement pretty much speaks for itself. Everyone should be equal before the law. Everyone should be treated equally by the FEC, and there does seem to be a problem where some people just are not treated the same way as everybody else. And we went into detail in our statement about a number of what looked to us to be well-justified complaints that merited an investigation and could not get 4 votes in any of them. And there is, as you know, a long list, and we supported the recommendations of our nonpartisan professional staff.
If I may join in, I join in with my colleague said, and thank you for the question. The particular matter that you're mentioning, in that instance, the allegations were that the Trump Committee and a joint fundraising committee had misreported the amount of money, and we're talking about $781 million. The reports had said this was for consulting or photography or something like that, but in actuality, there seemed to be credible outside news sources. The Wall Street Journal, I believe, was one of those, the New York Times, that had reported that the money was actually used to pay the salary payments for the former president's family members and close associates. This matter was a reason to believe recommendation by the nonpartisan staff, and the recommendation was to move forward with an investigation, not a probable cause finding. as we all know, well, the people in this aisle know, excuse me, is that reason to believe is the initial determination where we decide if we're going to conciliate or to investigate. This would have been an investigation, merely the opportunity to look into the information. But as the Vice Chair had mentioned, the end result is that this was dismissed under a heckler.
And your statement also identified a similar matter when the commission found reason to believe a violation occurred. The difference in that was it was Senator Clinton and the DNC, you decided to pursue the investigation along with your colleagues. But it suggests that there's a dual standard here, and I wonder if either of you would want to comment on how you feel this impacts the public confidence in the FEC.
Thank you. I think that one of the things that's important for this agency is that we be considered nonpartisan when we're considering the matters. I understand that there's a D by my name, but there's not something like that when we're looking at a matter. And it's important to note that this recommendation to go forward in the DNC Hillary Clinton matter that you mentioned was a recommendation by a nonpartisan staff. They also made an analogy inside of that report that they found the circumstances quite similar to the previous one that you mentioned regarding the former president. So in my consideration, I did vote to find reason to believe for that one. I felt that it was analogous in the facts and the law. Thank you.
Thank you. I'm sorry that we don't have more time, and I would suggest we should bring the nonpartisan professional staff in to talk about some of these at a future hearing. I would urge the chair to consider that. But before I yield, Mr. Chairman, I seek unanimous consent to enter the following into the record. Committee on House Administration's July 18th, 2022, May 24th, 2023, August 28th of 2023 oversight letters to the FEC and the FEC's corresponding responses and attachments. I again want to extend my sincere thanks to the professional staff of the FEC for their quick and thorough work responding to the committee's questions. And
Without objection.
thank you, and I yield back, Mr. Chair.
Gentleman yields back. Ms. Bice is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for the witnesses for being with us this morning. Today is the first time in 12 years the Committee on House Administration has held an oversight hearing with the Federal Election Commission. It is vital that the FEC remain nonpartisan and continue to work together to ensure integrity in America's elections. To this point, the Democrats for the People Act, introduced last Congress, would reduce the FEC's number of commissioners from 6 to 5, making it a partisan commission. Since 2021, the commission has closed 521 matters with an agreement rate of over 90%. Well done. It is important that we uphold the bipartisan nature of the FEC because it serves to protect the First Amendment rights of all Americans. My first question is to Commissioner Weintraub. By statute, the commissioner serves in a seat with a revolving 6-year term, but may continue to serve past the term's expiration until he or she is replaced. You were first recess appointed to the FEC on December 9th, 2002, and later formally confirmed in 2003. Your term actually expired in 2007. You have served on the FEC for more than 20 years, 15 since your term expired. The next most senior commissioner is Commissioner Traynor, who was appointed in 2020. Commissioner Weintraub, let me ask you, the FEC is not meant to be a lifetime appointment. Why do you believe you're still on the commission?
Because I haven't been replaced.
Do you think we should be looking for a replacement now?
I believe that is a decision for the president.
Are you ready for the president to nominate someone to replace you?
That decision is out of my hands. If I am replaced, I will obviously leave. But the commission, as we have noted earlier, has been through several periods where we ran out of commissioners. We lost the quorum. So I am legally there until I get replaced.
Why do you think that the quorum was lost?
Because commissioners left and were not replaced.
Okay. All right. For Chair Lindenbaum or Vice Chair Cooksey, let me ask, the agency's 2024 budget request of $93.5 million represents a 14.5% increase from the 2023 appropriation of $81.6 million. As an appropriator, I feel like it is my duty to ask the question, can you explain why this increase is needed and what the agency plans to spend the money on?
Sure, I can get that started. And thank you for this question. This is one of the critical things that we're all working on and that we've really found consensus on. For over a decade, the Commission has not asked for or received additional funding. So we have not kept pace with inflation. The Inspector General's report to you all really makes this point quite well, that in today's dollars, we are at a huge deficiency, even though we have less staff than we had 12 years ago.
How many staff do you have currently?
I believe it's 305 at this moment, and that's because of recent hiring due to our fiscal year of 2023 funding. Before that, we were at our lowest ever at somewhere around 200, 295. That makes a huge difference.
What are the biggest costs to your agency?
I believe it is staff and IT and infrastructure. As I've said, one of the biggest things that we do is collect all of those campaign finance reports and publish them. As somebody who's worked in states across the country on campaign finance and for clients who can't trust that when they file their reports, they're actually going to go through and can't, you all know what it's like when you're timing out. I'm going to file my report at midnight and it's going to be okay. It's going to go through. Well, I've been there when you file your report at midnight and it does not go through. We need to make sure that when you all file your reports, they're going to go through and the public can view them. At this point, we have been making do with what we have. We have critical vulnerabilities. Our staff is cobbling things together and doing an incredible job of it. But we need to improve all of these systems.
My time is limited. I have about
I'm
30
so
seconds.
sorry.
Let me follow up with another area that you mentioned already, and that's IT operations. Can you talk a little bit about the cost increases on that and what we can do to address it?
Yeah, I can, Mr. Vice Chair.
Thank you for the question. I've been on the IT committee since I joined the commission. I think as every member is aware, the volume of transactions and contributions that we report is increasing exponentially over the last few cycles. The IT infrastructure has not kept pace. We need additional investments in order to keep our IT at state of the art.
With that, Mr. Chairman, I yield.
Thank you very much. Ms. Torres is recognized for 5 minutes.
I would like to yield to the ranking member for a few seconds.
Yeah, thank you, Ms. Torres. I just wanted to make a point which has been made over and over again, that of the 500-plus issues before the panel, that the vast majority, 90%, have been agreed to unanimously. I think it's a little bit like comparing suspension votes here and unanimous consent motions that are agreed to. Often, it's just the routine matters. I think the thing to remember is where the professional staff has nearly 110 times requested investigations, only 12 of them have we had the ability to move forward on investigations. So I just wanted to make the point that it's easy to look at the easy things. The question is on the tough things where the enforcement really matters. I think we've seen a complete partisan breakdown. With that, I yield back to Ms. Torres. Thank you.
Thank you, Ranking Member and Chairman. Commissioner Traynor, on August 7th, 2023, the Office of the Inspector General released a summary of an investigation into your conduct and allegations of ethic violations related to your participation on a 2021 event hosted by Denton County Republican Party, where during your tenure as a FEC commissioner, you were billed as a member of the Trump elections team. The investigation also considered your failure to recuse yourself from matters before the commission related to former President Donald Trump. My question to you is, prior to your appointment as an FEC commissioner, you served as legal counsel representing the 2016 Trump campaign, correct?
Thank you for that question, Representative. The answer is yes.
Thank you. When did your representation of the Trump campaign cease?
In 2016.
As volunteer or as paid? Or both?
Well, I was volunteer during the campaign itself, during the recounts that happened after it was a paid position.
So as recent as the November election 2 years ago?
Of 2016.
Of 2016, okay. Do you have any ongoing legal duties to the Trump campaign as a former client?
No, Representative, I don't. As you probably know, the statute that governs participation as commissioner on the FEC prohibits us from having any outside employment.
Okay. The case that you cited regarding a Facebook, an accusation that they has spent, I can't quote you directly, but some $30,000 in ads. Was that, I'm sort of walking away that you are saying that Anonymous has a voting record and has a last name?
I'm not sure that I fully understand your question. In my written testimony, I did cite to the...
No, in your verbal testimony, you said that there was a Facebook page created, and there was a complaint about that page posting or spending some $30,000+. It was an anonymous page, but you said that even though it was an anonymous page, it was okay, and you didn't move forward with a complaint. You cited that as a gross complaint.
So the complaint was dismissed 5-1 by the commission. I voted actually not to dismiss the complaint, but the actions of Mr. Utley in that particular case are protected speech under the Supreme Court's precedent in Talley versus California.
I understand
and
that,
McIntyre.
but the Facebook page was not under his name. It was an anonymous page, correct?
It was entitled Elect Trump 2020.
But it didn't have his name. And was that election 2020, was that a committee that had filed campaign documents with you?
Not that I'm aware of.
So I don't understand how that would be something that would be excused. And I know that you voted the opposite.
So just to be clear, Mr. Utley spent $483, not $34,000 as he was accused of. And so when you have an individual who takes $483 of their own money and decides to engage in political speech.
But in an anonymous way.
In an anonymous way. The Supreme Court has said in 2 prior cases that is allowed for the individual to engage in that level of anonymous speech outside of the jurisdiction of the commission.
So in other words, the Supreme Court is saying anonymous does have a voting record.
I'm not sure what you mean by voting record, but yes, the Supreme Court has sanctioned anonymous political speech.
Thank you. I appreciate your feedback.
Gentleman yields back. Mr. Loudermilk's recognized for 5 minutes.
Well, thank you, Mr. Chairman. Thank you all for being here today. Ms. Weintraub, some series of questions for you. Commissioner, a Freedom of Information Act request to the Commission indicates that you cooperated with and assisted the Select Committee on January 6th back in October of 2021. What did you discuss in your meeting with the Select Committee?
You know, I don't know if I can fully recall off the top of my head. I wasn't expecting to be asked about that. I can tell you generally that I took a phone call with some of their staff, and they asked me questions about the law, areas of the law that I am fairly expert in. Didn't get into any factual analysis. It was really just a discussion of what the law permits and doesn't permit. But I would be hard-pressed to come up with the details at this
So was there only one conversation?
I believe so.
Okay. Do you know if that was documented, either with you or by the January 6th committee or the commission?
I don't think that I have any documentation, and I couldn't say whether they do.
Did you seek advice from other commissioners before engaging with the Select Committee or notify them that you were going to do this?
I don't recall. It's not at all unusual for people out in the world to reach out to commissioners and say, hey, you're an expert on campaign finance law. Can we ask you a few questions?
Okay. Did you play any other role or give any other assistance to the January 6th committee?
I don't believe so, no.
Okay, thank you for that. Commissioner Weintraub, the greatest source of dysfunction at the FEC in recent years has been caused by the Democratic commissioners' deliberate strategy of blocking the closure of enforcement cases and forcing the agency to default in litigation. You and your staff have proudly claimed responsibility for disrupting the FEC's enforcement work in order to allow left-wing groups to sue the agency and to bypass the commission to sue political campaigns and groups. A federal court in the case of Heritage Action for America versus FEC and the Campaign Legal Center versus Heritage Action for America has recently ruled that your actions were illegal and violated the Administrative Procedures Act. Do you still stand by that strategy?
Well, I would have to respectfully disagree with a lot of the characterizations in the question, but the law empowers me as a commissioner to vote on whether to close matters, to dismiss the cases, and I make my decisions in each case in the way that I think the law and the facts of those cases dictate. And the law also empowers me to vote on whether to defend the agency in litigation. That is something that Congress put into the statute and required a four-vote required four votes in order to defend. I think that was actually a good move because what it does is it provides some incentive to the commission to try and work together to make sure that they have four votes to support the substance of what the commission is doing, and that way there will be four votes to defend.
What the strategy of blocking, as is read here, means? Are you just refusing to vote?
No, there may have been some, I'd have to go back and look at the individual votes. There may have been some votes that I abstained on and other votes that I thought that the agency should not send its lawyers to court to defend the positions of less than half of the commission. None of these involved majority decisions. And by the way, there's a very small handful of cases that we're talking about. Again, going back to your premises, this did not largely disrupt the operations of the agency.
All right, we'll move on. The New York Times published an article on June 8, 2021 titled, "Democrats' Improbable New FEC Strategy, More Deadlock Than Ever." Commissioner Weintraub, do you stand by its content that your goal in the agency appears to be to take a commission widely seen as dysfunctional and create further deadlock, compelling federal courts to fill the breach when it comes to policing federal election law?
Again, I would not agree with that characterization necessarily, but I do think the courts can play a constructive role.
Did you ever discuss the strategy with Campaign Legal Center or other outside parties?
Nope.
Okay. Mr. Chairman, without objection, I'd like to enter into the record three documents. One is the Legal News Line, FOIA records, January 6th, House Select Committee investigator consulted with FEC commissioners sparking ethics questions. Second is United States District Court for the District of Columbia, memorandum and opinion. And the third is an article from the New York Times, "Democrats' Improbable New FEC Strategy, More Deadlock Than Ever."
Without objection, so ordered.
And I yield back.
Gentleman yields back. Mr. Kilmer, if you'd like to go right away, otherwise we can go to Republican and let you collect your thoughts. Mr. Kilmer is recognized for 5 minutes.
Thanks, Mr. Chair. Thanks for being with us. Appreciate you. I want to take a moment to recognize the FEC's unanimous decision to advance public citizens' petition, which requests a rulemaking to address the use of generative artificial intelligence in deceptive campaign advertisements. I was among the 50 members of Congress who signed on to a letter led by Congressman Schiff urging the FEC to reconsider its initial decision not to seek public comment. I'm grateful for your attention to what I and many of my colleagues perceive as real threats to our democratic institutions and the further proliferation of mis- and disinformation impacting the American electorate. Already, we have seen the dangerous use of generative AI to impersonate candidates and public figures. The potential for deception is a real and current threat. Indeed, in a report, the U.S. Department of Homeland Security has highlighted this liability, offering an example where synthetic media such as deepfakes, often created using generative AI, could be employed to shift the tide of an election or cause civic unrest close to a voting day. The increased presence of this kind of media in combination with a significant election next year should sound alarm bells for everyone. It's my view that the FEC is the governing body with the authority to conduct oversight of these challenges involving the use of generative AI in deceptive campaign ads, and I continue to urge action, including requirements to disclose campaign ads created by generative AI, as well as a prohibition on deliberately deceptive content in campaign ads created by generative AI. So, what can you do with your existing authority over deliberatively deceptive content and campaign ads created by generative AI? And where do you perceive the gaps in oversight over the full scope of issues that this technology presents to campaign ads and election law?
Thank you for that question. And of course, this is a hot topic that I think we all are discussing. We've been asked to discuss, and something that we're all considering along with you all. We have this petition for rulemaking that has a comment period, and I don't want to prejudge what we will or will not say about it. I can tell you that for me personally, the way that I'm looking at this are twofold. One is, do we have the jurisdiction to do anything about it? Our jurisdiction is quite narrow and just involves money and campaigns. So there has to be money behind an ad itself. And does our fraudulent misrepresentation statute cover anything that can be involved here? I use a lot of examples that I won't waste the time with here, but I have some good ones that I'm happy to talk to you about that discuss what would be covered and what wouldn't be covered. But even with or without AI, if a candidate or their agent creates an ad that makes it appear like their opponent made that ad, then that's already covered, again, with or without AI. On the policy side, what I am thinking about, and that I hope we're all thinking about, is what is different with AI compared to how things currently work. Right now, you can chop up an ad and make it appear like a candidate said anything, with or without AI. What is that difference there? And how does the misinformation field that we have seen play out for years make this so much worse? So I think those are the policy sides that you all are thinking about, we are certainly thinking about, and if asked, we would hope that, well, I would certainly hope that Congress is considering ways to regulate it. I have concerns about over-inclusive disclaimer requirements. I think that if we require a disclaimer on every ad with AI, then it is going to defeat the whole purpose. We want the viewer to know why it has AI, and we want it to not become like every ad has a disclaimer. I think it's important to give that to the viewer. But again, I really hope that this comment period brings in helpful comments for us and for you all. And we will see where that comes when it closes in 30 days. So thank you.
Okay. Anybody else want to take a swing at that pitch?
Thank you, Representative. I agree with what Chair Lindenbaum just said. I'll just add that obviously private entities are free to impose their own limits and disclosure requirements on the ads that they host on their own platforms. I know Google has made announcements about their own imposed disclosure requirements on AI, and I expect that a lot of other entities will as well. And so I think we'll be interested to see how that plays out in practice.
Thanks. I yield back.
Gentleman yields back. Dr. Murphy is recognized for 5 minutes.
Thank you, Mr. Chairman. I share my colleagues' concerns about AI. In fact, it petrifies me about how realistic some of these things are. I was just reading about deep faking, and good Lord, who knows what this is going to look like in 20 years. And it's up to you guys to actually be objective and clean and make sure that things are free and are fair. Ms. Weintraub, how long have you been serving?
Since the end of 2002.
That's 21 years is best my math, right?
Almost.
So how long is a normal term?
6 years.
6 years. What's that all about?
The statute provides that commissioners, once they've been confirmed, can serve until they get replaced. And as I said, there's been a problem in the past with commissioners leaving and not getting replaced, and then we run out of commissioners and the commission doesn't have a quorum to function.
Well, I say this because there have been some questions about you serving so long and thoughts about you being more partisan, really, than we would like to see on the FEC. And that's just concerning. Realistically speaking, and I'll ask Mr. Cooksey, realistically speaking, how long should commissioners stay on? I don't mean to be as divisive within the commission, but, you know, I think let's be fair, and we don't need people to stay on forever.
Thank you for the question, Congressman. I mean, realistically, Congress set a 6-year term. I think 6 years is a good amount of time. No one voted for me to be on the commission. It's not a lifetime appointment. I'm not part of the federal judiciary. And there is a tendency, I think, to provide a better public service when you have fresher experience from the private sector, from other parts of government. And so I think 6 years is a good number.
Well, don't you think kind of a holdover term creates somewhat of a bad incentive?
Respectfully, as a former Senate staffer, I will say that the Senate is always looking for an excuse to avoid another nomination.
Well, should that commissioner try to be proactive in finding a replacement?
In my opinion, I think commissioners should always be on the lookout for other people who might bring value to the commission with service.
I'm not a legal person. I'm just a dumb surgeon. I look at, other than maybe the Supreme Court, you look at judicial candidates who are elected and put in place to be fair. I believe you guys are judges in a way, very much so. And so I think it would be the expectation of the American public that there be turnover, to bring in fresh faces, just like they scream at us for term limits, the same type of things. So Ms. Weintraub, with all due respect, I hope you will start working on your replacement.
Congressman, with all due respect, that's really the president's job. It's not mine.
Well, maybe you might call him up and suggest that. I just think, enough is enough. We don't need career politicians more than career commissioners. So that said, let me get back a little bit, I guess, to the AI stuff, which, as I said, is absolutely terrifying. You guys have submitted public comment. What do you expect to gain from it? What do you expect to hear? What do you expect to act from it?
I could speak on behalf of myself. I hope that we get good comments on if we have the authority to regulate in this area, and if so, which ways will be the most helpful to the public and to the participants in the political process. Again, authority, as we discuss it internally, one of the biggest concerns that keeps getting raised is, does our statute does FECA give us the authority to regulate this in any way that is different than the way that we regulate anything else?
I have no doubt in my mind whatsoever that China will be actively involved, Russia will be actively involved in trying to manipulate our elections. I mean, the president of Mexico said point blank, he was planning on meddling in the election, actively participating in the elections of the United States. Wouldn't it be great if we just had free and fair elections and the people of America, all who are eligible to vote, were able to vote in a very judicious and open manner? I think that's the aim, regardless of whatever your political proclivities are to do. So.
I would completely agree with that. Thank you.
Mr. Traynor, let me just ask you this other question, because you said a statement earlier that really has bothered me. Who is the entity, who is the persons, who is the committee that's pushing for the secret sharing between the FEC and the DOJ?
The sharing, that's a memorandum of understanding between the Commission and the Department of Justice to share that information. Most of the time, those are requests that we receive from the Department of Justice, and I've made it very clear in my comments and my votes that Congress has addressed when the Commission should have conversations with the Department of Justice, and that is after we have completed our investigation. If we find that someone knowingly and willfully violated the law, we would turn that information over to the Department of Justice. What we see happening now is that the Department of Justice actually circumventing the processes at the FEC and coming in up front and saying, we want to do a criminal investigation before you've finished your investigation. They ask us to stop, turn over our documents, turn over conversations that campaigns have had with our RAD analysts, and give it to them so that they can begin a criminal investigation before we've even finished. And a lot of times, the statute of limitations for us runs out, and we may or may not get that case back from the Department of Justice.
This is the absolute weaponization of our government.
Without question.
Thank you, Mr. Chairman. I'll yield back.
Gentleman yields back. Mr. Kerry is recognized for 5 minutes.
Thank you, Mr. Chairman, and I thank the ranking member as well. Commissioner Traynor, under our Constitution, who is given the primary responsibility in administering elections in the United States? Is it the federal government of the states?
The states.
And this principle is enshrined in Article 1, Section 4, commonly referred to as the Election Clause, correct?
That is correct.
So why did our founding fathers give states this primary responsibility?
The Founding Fathers gave that responsibility to the states because each state is responsible for how they appoint electors, how members of Congress are elected. Ultimately, the membership is decided up here, but at the individual states, they know best how to manage those elections.
So what are the benefits of 50 different state election systems that a one-size-fits-all federal system cannot afford?
Well, there's no benefit to a one-size-fits-all, given all of the complications. Having worked at the Secretary of State's office in Texas and managed elections, Texas has 254 counties. Some people vote on machines, some people vote on paper. There are a lot of things that go into that Congress could never take into account, and I think it's why it's important that y'all have passed this ACE Act to kind of reset where the governance of elections happens.
Much of the campaign finance law, as I found out, is very complex and convoluted and involves a lot of unnecessary paperwork, in my opinion, as well, and with all due respect, a lot of expensive lawyers. Can you just briefly explain why spending money on political activities qualifies as protected speech under the First Amendment?
Oh, well, the United States Supreme Court has decided that early on after the commission was created that the dollars that are spent equal political speech. And so everything that we deal with at the commission, because it deals with the campaign finance issues, touches on that First Amendment aspect.
So let me just give one example. Wouldn't we all recognize the obvious First Amendment problem if Congress restricts how much money the Washington Post or the New York Times or the Wall Street Journal could spend?
I'm sorry, I didn't understand your question.
I mean, wouldn't we, if we recognize the obvious First Amendment problem, if Congress would somehow restrict how much money the Washington Post, the New York Times, or the Wall Street Journal could actually spend?
Oh, very clearly that would be a violation of the First Amendment.
So with this in mind, why is it so difficult for people to understand the same obvious principle when it's applied to political campaigns?
Ultimately, it's a function of actually what Commissioner Dickerson testified to. It's the hodgepodge that the Federal Election Campaign Act has become because the courts have nullified so many provisions within it that it actually it's something that needs to be reset and looked at and have provisions that are still on the books taken out so that an average citizen could look at that and say, here's what I can and cannot do with regard to that. And ultimately, it comes down to whether or not really the only thing we need to police is whether or not there's a corrupting influence of money. That's the only thing that we need to be policing.
All right, well, I appreciate and I appreciate all of you guys sitting here today and testifying. And with that, Mr. Chairman, I yield back.
Gentleman yields back. Mr. D'Esposito is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here this morning and this afternoon. Ms. Lindenbaum, a top FEC legislative recommendation that the American Confidence in Elections Act suggests amending the foreign national prohibition to include state and local ballot initiatives, referenda, and recall elections. Many aspects of federal law already prohibit foreign nationals from participating in our elections. Can you briefly summarize how?
Can I briefly summarize how the law is already?
Correct.
Yeah. So we have a number of different statutes. The FICA completely restricts the ability for foreign nationals to contribute to any campaign, be it federal or state campaigns. It also has limitations that we have regulated around and issued advisory opinions on how involved a foreign national can be in the actual campaign. Can they serve as campaign manager? Can they serve as a volunteer? Can they serve as somewhere in between and have decision-making authority?
Okay. Is it true that there are loopholes for state and local ballot initiatives, referendums, and recall elections?
Yes.
Okay. Fortunately, in my state, a judge of New York's State Supreme Court struck down a law passed by the New York City Council to allow non-citizens to vote in local elections, which would have allowed an estimated 800,000 non-citizens to vote. Do you believe non-citizens should vote in our nation's elections?
I leave that up to the jurisdiction. I think some jurisdictions it has worked well, but I think in local elections, that is their choice.
Okay. My next questions are for Mr. Cooksey. There has been a narrative for the last several years that the FEC doesn't do its job. It's dysfunctional, it's chaotic. Do you agree with this narrative, or do you think the agency actually operates pretty well?
I absolutely don't agree with that narrative. I think the agency, despite our bipartisan structure, actually gets a lot done.
I would agree. Isn't it true that before 2021, the FEC had vacancies and had not had full 6 commissioners since 2017.
In 2017 was the first time we lost a commissioner without a replacement, and we went down to 5. By 2019, we had lost the 4 members necessary to do any real business, and so that was a big struggle for the agency.
Okay, and now, isn't it also true that because of those vacancies, the FEC went almost a half a year without a quorum?
That's right. It was about 16 months.
Okay. And is it true that vacancies led to a backlog of almost 500 cases?
That's true.
As you probably know, the Democrats for the People's Act would turn the agency into a 5-commissioner partisan agency. In your opinion, how dangerous is that proposal?
I think Congress was extremely wise in structuring the FEC as a bipartisan, evenly numbered commission that requires bipartisan agreement to go forward. It is the most important structural feature of the agency to prevent it from engaging in partisan or politically motivated investigations.
So you would agree that it's important for the FEC to maintain its 6-commissioner bipartisan status?
Absolutely.
Well, thank you all for being here. I appreciate all of your work. Mr. Chairman, I yield back.
Gentleman yields back. I now recognize myself for 5 minutes for the purpose of questioning our witnesses. One of my goals is to really make sure we keep out foreign interference in our elections. It's actually why I think American elections should be for American citizens, as was questioned earlier. But if I can, Mr. Cooksey, let me run through a scenario that's specific to the FEC in this space. Under current law, could a non-U.S. citizen, a Russian national, a Swiss billionaire, donate to a U.S. nonprofit?
Under current law, foreign nationals are entitled to make contributions to issue advocacy organizations or charities.
But they could donate to a nonprofit, so to issue advocacy or other areas.
Correct.
And then could that issue advocacy nonprofit contribute to a super PAC?
Generally speaking, yes, unless the foreign national were specifically involved in the decision-making, that would be prohibited. But if the organization's acting independently, yes, they can do that.
But if they had good attorneys, they could paper over that, and they could avoid direct relation into the super PAC. So you're saying that a foreign national could donate to a 501c4, and the 501c4 could then create almost a slush fund and transfer that to a super PAC, and if done directly to the super PAC, that would be prevented, right?
Correct. It's illegal for foreign nationals to make contributions to super PACs.
So effectively, there's a loophole that would currently allow a foreign national to functionally channel the money through a 501c4, channel that into a super PAC, and then run ads that would otherwise be prevented?
As you've laid it out, that could be done legally under current law.
And do you think that that loophole should be closed?
I leave it up to Congress, but I would say that generally speaking, the Commission is always concerned with foreign national influence in our elections. We have made a number of recommendations to Congress on how to expand our authorities for removing foreign influence in our elections. I think that is a very important proposal you're laying out that Congress should consider. That would make a big difference.
So let me put it the other way. Do you think the loophole should remain open?
Absolutely not.
Does anyone on the Commission think this loophole should remain open? I'll take that as a no from all of our commissioners. I think it is paramount that we close this loophole. It's being utilized, I think, to allow foreign interference in our elections. I think we've seen direct evidence of this. It's one of the reasons that we include language in the ACE Act to close this loophole. I think the more we're working to avoid foreign interference in U.S. elections, the better, and I think it's something that we should take seriously in Congress. Now that we've identified the loophole, we've seen foreign nationals utilize this loophole. I think it's absolutely essential that we work to close this. Let me shift gears slightly. Mr. Cook, I'm sticking with you. We've heard a lot of talk today from my colleagues about on the left that the FEC isn't doing its job and there should be structurally reformed. And I just want to dive into this slightly. When the FEC got 6 commissioners in 2021, the first time it had full membership since 2017, was there a backlog of about 500 cases?
That's right.
And then since that time, the agency's closed 524 enforcement matters with an agreement rate of 90%. Is that correct?
I think that's the right way to look at the statistics, yes.
And so 90% agreement in 521 cases, is that historic? How does that compare kind of the history of that as we just kind of conceptualize this for us.
Sure. So actually, over the last years, since we regained the quorum, our agreement rate is going up. So if you look at, for example, the period of 2019 and 2020, and by agreement, I mean cases in which we didn't fully divide on all the merits issues, right? We reached some kind of bipartisan agreement about the merits. Going back when we had less than the full 6 commissioners, there were disagreement rates in the high teen percents and the 20%. Year to date, for fiscal year 2023, our disagreement rate is 5%. In 95% of our cases over the last 9 months, we've reached a bipartisan agreement.
Okay. I think that's helpful for us to think about. I just want to come to you real quick, if I can, Ms. Weintraub. You were having the conversation with Ms. Bice. From the appointment standpoint, you could be reappointed. So it's not you. It's whether or not this appointment process should be occurring on a more regular basis. Is there anything restricting the president from reappointing you to your own seat?
The law does not permit that.
So I apologize then. So my research on this point was wrong. So if you could not be reappointed.
I do not believe so.
I think that's actually helpful for me. I will take the note of that. Have you had conversations with the White House regarding an appointment to your seat?
Not recently.
So when did you have conversations with the White House regarding an appointment to your seat?
Intermittently over the last 20 years.
If you had it, well, maybe we'll go through administrations. If you had it with any conversations with the Biden administration?
I believe so, but I'd rather not go into the details.
Well, I think it's somewhat relevant. I mean, it's a seat that has a 6-year term that you've remained in for a period of time. You've had intermittent conversations over the course of the last, I would assume, a handful of administrations, but most recently the Biden administration. Biden's currently the president. The Senate's in Democratic hands under Schumer. It's a Democratic seat that you sit in, but you're unwilling to comment on the time or place of any conversations you've had with the administration regarding an appointment to your seat?
I don't think I should comment on any conversations I've had with the White House.
And why do you think you should not?
Because I don't think that was their expectation when they talked to me, that I would be disclosing it in a public setting.
So, okay, so you've had private conversations with the White House that you don't want to disclose relating to an appointment to your seat? Is that a fair description of it?
I would amend that to say a conversation.
You've had a conversation. You've had intermittent conversations with administrations. You've had a conversation with the Biden administration or someone in the Biden administration that you're unwilling to disclose the time or place or manner of that conversation today?
That's correct.
Okay. Have you had conversations with any U.S. senator regarding the appointment to your seat?
Certainly not recently.
So not during the course of the Biden administration. You've had no conversations with the United States senator over the course of the past 3 years since the Biden election in 2020?
I don't want to make an absolute statement because I don't want to give you any misinformation, but it's certainly not a common occurrence in my day.
But do you have a recollection of that? I just want to be careful here. That you have no recollection of it, which that's an honorable statement if you have no recollection of it, or you have a recollection of it and you're unwilling to say.
I can't recall at the moment.
So you have no recollection of having a conversation with the United States Senator about an appointment to your seat. I would offer that if I had a conversation with the United States Senator about an appointment, I would personally probably recall that, but you don't have any recollection of that.
Not recently, no.
Not over the course of the Biden administration. I just wanted to define recently, because that recently is kind of a fluid term. So I'm not trying to ask you if you had it yesterday. I'm saying over the course of the Biden administration, have you had a conversation with the United States Senator regarding an appointment to the seat that you hold?
I honestly cannot recall. Nothing springs to mind.
That's honorable. So you then have no recollection of having a conversation with the United States Senator over the course of the past, going back to the election of President Biden in 2020. I just want to make sure that I'm confirming what you're saying.
Not that I recall.
Okay, fair enough. Let me come to one final point. I'll come back to you, Ms. Cooksey, Mr. Cooksey, if I can. One thing real quick here that I want to hit on, and that relates to Win Red and Act Blue. driven, one by the left, one by the right, fine. But often I'm hearing concerns that these donor reports are too large to be downloaded from the FEC's website. It sounds kind of technical, but a massive number of contributions, to both sides of the aisle, to political candidates of all stripes, are going through these two vehicles. Is that accurate, that these files are too large to be downloaded and reviewed by regular folks that don't have supercomputers?
Mr. Chairman, that is accurate. The exponential increase in the number of transactions that are being reported, again, through WinRed and ActBlue, makes for extremely large files that are very difficult to download.
And what should we do to change that? Or, I mean, they should be available to people. I assume everyone on the commission believes that these should be easily accessible to people. Is the whole point of our disclosure regime. But that disclosure regime has a technological hiccup. Is that a fair assessment?
Yes.
And what's blocking you, or is there a federal law? How do we work to change that? Because I think all of us, I would assume all of us think that should be fully available and accessible in the light of disclosure. I think that's important. I assume everyone all of the commissioners would agree with that. What's blocking that? What's the hiccup?
I think I would flag two things. One is the requirements for how transactions are reported through conduit reporting of these WinRed transactions that leads to more individual contributions being reported and increases the size. Frankly, the other issue is IT infrastructure for the agency and the amount of funding that we need to process these reports on the front end to get them available to the public, which is itself its own kind of bottleneck.
Chairman, did you want to comment on anything about the technological side of how we get these out? I think this is kind of technical in matter. I'm not hyper-partisan.
Yeah, I would completely agree with that. And we also have this open comment period that we hope you will submit comments to on, and anybody else who's struggled to download those reports or those who are filing those reports. We've had issues also with those reports when those folks are filing amendments to their reports. So you can imagine what that has done for our staff and trying to work with it to make sure it doesn't all happen at once. Again, these are things that we can make significantly better with increased funding so that we aren't cobbling together old systems. But again, this comment period that Commissioner Dickerson and I have really launched, we hope will bring more of this to light.
Thank you very much. And let us know how we can work with you to assist that. I think it's a really important piece that we work to improve disclosure in this regard. I thank all of our commissioners for your willingness to come, your testimony today. I think it's enlightening. I think it's an opportunity for all of us to continue to work to strengthen our disclosure regime and to continue to work to allow the FEC to deliver on its goals and objectives. Our panel is now dismissed, and we will begin shortly with our second panel.
My light never came on, but it's on. It's on now.
Mr. Chairman,
Gentleman's recognized.
I have a statement, motion for the record. In light of the discussions today with some of the partisanship.
Well, tell you what, let's wait just before this panel's set, and we'll do it while we got the mic.
It is good swag.
Thank you. Nope. The greatest compliment a congressional panel can give you. You know this, right? Is that on or off?
It's still
Inspector General Skinner, we appreciate being with us today and look forward to your testimony. Mr. Skinner brings 10 years of Inspector General experience, including conducting investigations, inspections, and internal audits. Previously, Mr. Skinner worked as Deputy Inspector General for the Office of Naval Research for 6 years. Pursuant to paragraph B of Committee Rules 6, the witness panel, Mr. Skinner, will please stand and raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Let the record show that the witness answered in the affirmative and may be seated. I now recognize Inspector General for 5 minutes for the purpose of giving an opening statement.
Thank you, Chairman Stile, Ranking Member Morelli, and distinguished members of the committee. Thank you for inviting me to appear before you today to testify about the work of the Office of the Inspector General for the Federal Election Commission. We appreciate your interest and continued support for our work. Our mission is to detect and prevent fraud, waste, and abuse and other violations of law, and to promote economy, efficiency, and effectiveness in the operations of the FEC. The OIG strives to promote improvements to FEC operations, programs, and initiatives by independently conducting value audit engagements that include audits, evaluations, and investigations. Each year, we are required to identify the most serious management and performance challenges facing the Commission. Accordingly, I'd like to spend a few minutes today to talk about some of the most significant challenges facing the Commission that my office has identified and reported. Next year will mark the 50th anniversary of the FEC. Needless to say, much has changed in that half-century. In 1976, the first presidential election cycle after the FEC was established, federal campaigns raised and spent around $300 million in total. In the 2020 presidential election cycle, that number was $14.4 billion. Much of that increase in campaign fundraising and spending has occurred since U.S. Supreme Court's 2010 decision, Citizens United v. FEC. That decision significantly altered the legal landscape regulated by the FEC and led to a rapid growth in contributions to campaigns and committees, both in total dollars and in the number of transactions subject to FEC oversight. As shown in Figure 1, total spending on federal campaigns during the presidential election cycles increased from $6.3 billion in 2012 to approximately $14.4 billion in 2020. Expenditures during midterm elections increased from $3.6 billion in 2010 to $8.9 billion in 2022. Similarly, the number of transactions subject to FEC oversight increased more than 20-fold, from 28 million to 616 million during that same period. Despite those increased obligations, the FEC's resources have diminished over the same time frame. As you'll see in Figure 2, the Commission's budget has increased by an average of only 1.6% per year. As shown in Figure 3, the agency's annual budget, in fact, has decreased when adjusted for inflation. The FEC's 2023 budget was approximately 10.6% less than its 2010 budget in current dollars. These limitations have had significant impacts on the agency. Most notably, it has caused a reduction in the size of the FEC's workforce. As shown in Figure 4, from 2010 to present, the agency's workforce decreased from 348 to 305 staff. In summary, the agency has lost 12% of its workforce during a period in which its workload has skyrocketed. These reductions have been entirely among career agency staff. They include campaign finance analysts, attorneys, and auditors who carry out the essential functions of the FEC. One impact is that the FEC ranked last among comparable agencies in a 2021 survey of employee satisfaction and engagement. In addition, having worked in the federal OIG community for 15 years, I can tell you from experience that agencies are reluctant to report performance challenges. As such, it is significant that the FEC has done just that and has reported that performance has been adversely impacted by staff shortages and that performance targets have been reduced as a result. For example, the agency reported that it has not met performance goals to complete audits and process committee reports on time due to these staff shortages. Agency resource limitations affect the implementation of OIG recommendations. As detailed further in my written testimony and in our semi-annual reports to Congress, the OIG has addressed 173 hotline inquiries, conducted numerous evaluations and audits, and issued 25 recommendations in the last 3 years. Currently, there remain 20 open recommendations. Those recommendations cover agency operations and programs ranging from improvements in campaign finance oversight, stronger regulation of unlawful foreign contributions, and improvements to agency financial and human capital management. My staff and I have a good working relationships with the Commission and agency leadership, who have been open in their dialogue with us in response to our recommendations. A common refrain in that dialogue has been that the agency's limited resources impede implementation of OIG recommendations. Despite these challenges, my office will continue to provide oversight of the FEC to include developing actionable recommendations to improve agency operations and programs. In closing, I want to thank Chairman Stile, Ranking Member Morelli, and members of the committee for this opportunity to testify today. Going forward, the OIG remains committed to conducting engagements in support of the FEC. I look forward to continuing to work with my OIG team, the Commission, members of Congress, and SIGI to provide oversight of the FEC on behalf of the American taxpayers. Our work to date reflects the exceptional efforts of the OIG team. It is an honor and a privilege to lead such a talented group of individuals. Thank you again for this opportunity, and if you have any questions, I will be happy to address them at this time.
Thank you very much, Inspector General Skinner. We'll now begin our questions, and I'll recognize Mr. Carey for 5 minutes.
Thank you, Mr. Chairman. I also want to thank the ranking member. Mr. Skinner, General, can you describe your working relationship with the 6 commissioners?
Yes, that's a great question. We have an excellent working relationship with the commissioners. We meet with the chair and vice chair regularly to provide them updates into all aspects of our work, our audits, inspections, evaluations, and to some extent, just the investigations that we're working. We usually meet with them, I would say, on a quarterly basis, but we're available when high priority issues arise. We let them know and inform them. And with agency senior leadership, we usually meet with them, I would say, every other week, just to kind of get an idea of what's going on and to provide them input into the work that we're doing.
So when or if you seek assistance from the commissioners in an investigation, other than when a commissioner is under investigation, is that assistance given to you? And I'm guessing from your statement it is?
From cooperation from the commission, yes, generally it is.
Okay. So when you release reports, are the commissioners generally supportive of your work?
They are.
Do you feel that you have sufficient independence from the commissioners so your work is completed without interference?
We do.
How would you describe the morale at the FEC and your office in general?
That's a good question. That's something that my office has started to inquire on. We're currently looking into how that type of review would look. I can tell you from a 2021 survey, the FEC ranked last for employee satisfaction and engagement. So that's definitely something we noted in our semi-annual reports and in our management challenges document to Congress. So that's something that's on our radar, yes.
All right, I appreciate your candor with that. In your last semi-annual report to Congress, you stated you've addressed 173 hotline inquiries.
Yes.
What did some of those inquiries entail?
They range from a variety of issues. I think we have a chart in the written testimony. Some of the matters that we are referred, they don't belong to the FEC. It's not a matter within our cognizance. It could be a matter for the FCC, could be a matter for a state or local election jurisdiction. So in those cases, we either will refer the matter or assist the complainant if we know. Sometimes we don't know who the person is submitting the complaint. We have a multitude of avenues for people to bring issues to us, including our hotline portal, and they can do so confidentially or anonymously.
Okay.
So I would say those issues just vary widely.
So are there any steps that you would request Congress to maybe fix some of the problems that you have?
I'm sorry, can you clarify the question?
Are there any steps that you think that we as Congress need to help facilitate what you need to do?
For our work, I would say, one of the most important I guess, issues in the OIG community is testimonial subpoena authority. We currently don't have that. The IG Act calls for documentary. We have that documentary subpoena authority. We do not have testimonial. Case in point, recently we had a commissioner refuse to speak with us in one of our investigations. We cannot compel him or her to speak with us. So testimonial subpoena authority would greatly help us leverage speaking to individuals when it comes to administrative investigations and gathering all the relevant facts of the case.
Okay, that's great to know. Again, Mr. Chairman and Ranking Member, I appreciate your indulgence for allowing me to go, and I yield back.
Thank you very much, Mr. Carey. The Ranking Member, Mr. Morelli, is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you, Inspector General, for being here this morning, for your service. This is the last panel. It seemed like an inquisition on Commissioner Weintraub, who is doing her duty and is serving under the statute that we've all agreed to and will continue her service. It did cause me to have some questions about commissioners. So I do want to ask you, I want to turn to the topic of an August 7th, 2023 investigative summary detailing your office's investigation of alleged ethics violations related to Commissioner Trainor's conduct surrounding his appearance at an event where he was billed at the event as a member of the Trump elections team, even though he serves as a commissioner in the Federal Election Commission, and about his non-recusal in FEC matters related to the 2016 Trump campaign. So just to ensure the record is clear on this point, the investigative summary noted that Commissioner Trainor did not participate in the investigation. Is that correct?
That is correct.
And when I say he did not participate in, effectively refused to participate, I just want to make that clear. Is that correct?
We gave him a number of opportunities to speak with us, and he failed to respond.
And is it true your office made numerous attempts over the course of several months to schedule an interview with Commissioner Trainor?
That is correct.
Is it also true that neither Commissioner Trainor nor his legal counsel responded to your numerous requests over the course of several months for his cooperation? Is that correct?
That is correct. I believe his counsel responded initially, and then we did fail to hear anything after that.
So, I just want to understand, is it fair to say that his lack of participation impeded your office's efforts to gather relevant evidence and resulted in some degree of uncertainty concerning the conclusions of that investigation?
It did. We would have liked to ask him a few questions that he did answer this morning. We would have liked to done that under our own investigation and under the IG oath.
So not cooperate with the Inspector General of the Elections Commission. Commenting on the investigation to the Washington Examiner, Commissioner Trainor, notably non-responsive to the OIG, but apparently not unresponsive to the press, especially when he considers it a favorable press, said he was outraged at the enormous waste of time and taxpayer money that was wasted on this matter. I want to ask you, General, do you think this matter would have moved along faster, using fewer resources and costing less money if Commissioner Trainor had simply cooperated with you?
Yes, I do think it would have been. We gave him a number of opportunities over the course of months to speak with us. We had a few key questions that could have helped us easily identify facts of the case and come to our conclusions.
Gotcha. Thank you. I just have a couple of minutes, so I'll ask you if you can just comment quickly. But in your March 2023 semi-annual report to Congress, you identified 5 serious management challenges the FEC must address to ensure proper functioning of the commission. Can you just please address any progress you think the management has made in addressing those challenges since the release of your report? And I'd ask you to do it quickly if you could.
Yes, I'll say some of the IT modernization efforts. I know the agency is actively working towards moving things to the cloud services. When it comes to personnel resources and human capital management, those things are pretty much in a stall, I think, because the budget issues and some of the personnel resource constraints that we've identified here and some of the data.
One of the things that was particularly concerning to me is the challenges the FEC faces in identifying and regulating unlawful foreign contributions. It's been talked about somewhat. In fact, your report states, the FEC's practice of relying on filers' self-certifications concerning potential foreign contributions pose a national security risk and provides insufficient oversight of possible illegal foreign donations. Can you please elaborate on the severity of the issue?
Yes,
and leaving aside any specific comments on particular bills, just sort of broadly, what do you think Congress can do to prevent the ongoing practice of illicit foreign contributions in our campaigns?
I think the commission could take corrective action in this case, and that would be to establish internal controls and internal procedures. And on the foreign contribution issue, I know the Reports Analysis Division has documented some adjustments, some thresholds in their internal policies which would, trigger requests for additional information, and that has not been approved by the commission.
And I want to just, if I could just finish, would you elaborate on the severity of the problem or the issue?
We have not dug we have not, gone any deeper into the issue. That was an investigation into a particular matter. We took the opportunity to look at the internal controls and some of the root cause analysis there. So in that case, we identified some of the issues when it came to internal procedures and processes with foreign contributions. But to your question, we have not done any further research at this time.
Very good. Thank you, sir, for your service, and I'll yield back.
Thank you.
Thank you very much. I now recognize myself for 5 minutes for the purpose of asking questions. If I can just begin at the top here, Mr. Skinner, about how you choose through what the matters that you're investigating. Is it the legitimacy of the complaints, the author, the subject matter? What drives that?
That's a great question. So we have a number of avenues for issues to be brought forward to our attention, and that includes the media, that includes our hotline portal, that includes a number of complaints. We have a thorough process internally. If an issue comes to us, the number one, like I said earlier, some issues do not belong in our swim lane. The number one thing we do is, does this involve an FEC program, process, or individual? Does it affect an FEC, conduct? Step two would be, if so, is there merit to the allegation? So if the allegation is true, does it violate a rule or standard? So those are just two quick steps that we discuss internally before we move forward in any preliminary inquiry or investigation.
So then in there, how do you deal with frivolous complaints? It sounds like they're weeded out at the front end?
Correct. Yes, we meet weekly with our senior investigators, and our counsel and deputy IG oversees everything.
And if you were to investigate a commissioner, when that decision is made, do you have contact with other commissioners, and how is that commissioner notified? Walk me through how that process would play out.
So I think sometimes it just depends on the matter at the time. We usually wouldn't reach out to a commissioner if they're the subject of the case. We like to interview them at the end once we have interviewed the relevant witnesses, obtained all the relevant documentation. So it just kind of depends on the case that comes in and what the issue is that we're looking at. If it's severe, of course, we'll bring it to their attention.
The ranking member just asked about the investigation into Commissioner Traynor. What's the bottom line of that investigation?
So the bottom line is he didn't participate, so we had to go on the relevant facts that we had already obtained, witness testimony, documentary testimony, things like that. So we had the standard of proof for us in an administrative investigation is preponderance of the evidence. So if the case led to a not substantiated allegation in that case, but we would have liked to ask Commissioner Traynor to clarify some of those things.
But at the end of the day, it was not substantiated.
We didn't have enough information to substantiate that.
So there was at the end of the day, there was no preponderance of the evidence.
No, that's correct.
And the report suggests that Commissioner Traynor's counsel participated, as you said. But when commissioners and investigators, how do they usually engage with your office?
If we've investigated a commissioner, is that the question?
You noted that Commissioner Traynor did not participate in the investigation. His counsel did not participate in the investigation. Okay.
Yeah.
How does a commissioner traditionally, I'm assuming there's a contrast in your opinion then as to how a commissioner would traditionally engage in an investigation
Typically,
with
we
your
get
office?
cooperation from the commission and all the employees of the agency. They respond to our inquiries and they respond to our requests for information and for interviews, typically.
Okay. In the 2024, shifting gears here, in the 2024 budget request, you asked for about $2 million in the aggregate for operations, 40,000 of that for training, about 8,000 of that amount to support the council of the inspector generals on integrity and efficiency. How should Congress look at that request in the context of the appropriations? And you shared some of your numbers earlier.
Yeah, for the IG and FY23, I'll be clear, we had sufficient budget in FY23 to conduct the work. Like the agency, a lot of our funds are tied up in personnel and benefits, but we do have some mandated assignments that we have to complete each year. So we asked for that amount. That would be sufficient enough for us to carry out our mission.
And does your office have a sufficient number of employees to carry out its mission?
Yes, we do. We have eight employees on staff.
So it's not a headcount issue as it relates to your investigation?
No headcount issues, no resource issues on our end currently. However, it's a small office. It wouldn't take much turnover to disrupt operations. So we are a firm believer in cross-training initiatives and utilizing the SIGI community, the OIG community of 14,000 employees.
One thing I've heard about, shifting gears again, one thing I've heard about as it relates to the FEC, I've had a couple of people mention to me a recurring question as it relates to X, the internet service formerly known as Twitter. I don't know how many people yet call it X. But an account, Alt FEC, much of the public, I think, believes that it may be a commissioner or a staff member working in a government agency, a federal employee that runs the account. Have you ever looked into that matter?
That is something we have not looked into, but of course, if there's additional information that your staff has, we'd be happy to hear it.
Has it ever been brought to your attention?
It has not been brought to our
Not been
attention.
brought to your attention. Fair enough. There's been colloquial comments to me that maybe people were misusing the government time or government resources as that, but I do not have evidence of that. I just shared. I was curious if that is something that had been brought to your attention. One final question for you as it relates to the underlying powers of your office, as it relates to subpoenaing documents that you don't have subpoena authority. Is that accurate?
Testimonial subpoena authority, that is accurate.
And would you believe so that subpoena authority, which Congress would need to provide, would that be helpful?
I think it'd be extremely helpful in our work.
Why?
I know,
I mean,
so,
go ahead.
what, case in point, we could speak with the commissioner. Our role is to obtain the facts. Right? We are fact finders. We cannot propose corrective action. We cannot take corrective action. We are fact finders, so if someone refuses to speak with us or work with us, that's an issue. We have some requirements in the IG Act. This is an OIG SIGI issue. This is one of 6 legislative priorities the IG community is pursuing with this Congress. So it would help us in a number of ways. It would help us if an employee retires and they don't have an obligation to speak with us and they have key facts relevant to the case. We'd like to use testimonial subpoena authority to get that information. So it would greatly increase, not only help our independence, but support the fact-finding efforts and the work that we do.
And other inspector generals have this authority, is that
A
correct?
majority
or is
of
this
them do
usually
not.
not the case?
That they do not. There may be, I think there's 1 or 2 special
Special cases that have it where in general, that is not held by the inspector general.
Correct.
Thank you very much. I appreciate your testimony here today, enlightening as we think and work to further strengthen and make sure that the FEC is carrying out its mission. I appreciate you being here today. And I'd like to thank all of our witnesses for appearing before us. It's been incredibly helpful. Members of the committee may have some additional questions for you. We ask you please respond to those questions in writing. Without objection, each member will have 5 legislative days to insert additional material into the record or to advise and extend their remark. If there's no further business, I thank the members for their participation. I thank the witnesses for their participation. Without objection, the committee stands adjourned.